So, with financial powers of attorney, the attorneys have limited powers to make gifts, and those are limited by Section 12. So, the attorney can make these gifts to charities or to relatives or people who are connected to the donor, not to the attorney, on customary occasions. And customary occasions is very broadly interpreted in the legislation, but it's subject to the reasonableness test. In other words, it's got to be reasonable, both in relation to the circumstance and the size of the donor's estate. Overarching that, of course, because attorneys have to make decisions in the best interests of the donor, they must also ensure that they comply with the fourth principle. Um, Ensuring the donor understands what the attorney can do and the extent, in particular, that an unrestricted power might mean that the donor is at greater risk of abuse, that there isn't any oversight, and if there are any limits, what those limits are. So, in other words, Section 12 is a particular limit in a financial power which the donor needs to be aware of. But then, of course, we can draft the power to mitigate or reduce any chance of abuse or misuse of that power. Now, one of my suggestions is to include some form of supervision. Deputyships are supervised by the OPG, attorneyships aren't supervised by any, but you could significantly reduce the risk of misuse of a power of attorney by that attorney having to provide some form of accounting to a third party.